Hi there, this is Jonathan Ginsberg. I'm a Social Security disability attorney, and today I'd like to report to you about some changes that Social Security has made in its rulemaking about how judges or adjudicators in the administrative level are supposed to evaluate medical evidence. And the big change that we're seeing is that Social Security has eliminated what is called the treating physician rule, and that is that up until now, medical evidence and opinions from a treating physician were to be given more weight than any other doctor. So if you had in your file, for example, 3 or 4 years of records from a treating physician and a functional capacity evaluation from that treating physician, that would be given more weight than an opinion by a consultative, somebody who you saw one time, a consultative physician or a non-examining physician that Social Security had your records looked at in-house. Now what they're looking at is a standard called persuasiveness, which basically says that all medical records are going to be given equal weight, but the judge can use persuasiveness to decide which ones are to be given controlling weight in making a decision. So, for example, if you have a situation where you have gone to the same doctor for 3 or 4 years, and the doctor's then given you a functional capacity evaluation, but the judge feels that the limitations identified in the functional capacity evaluation are not consistent with the reports, the ongoing medical reports, the judge can give that treating physician much less weight than the consultative physician and deny your case on that basis. Now, this sounds terrible, and certainly it can be abused. My sense is, though, that we're still going to have situations where the truth is going to remain that if you have ongoing medical treatment by a treating physician 3 or 4 years, that's going to sort of seem inherently more persuasive than a one-time visit or a report by a non-examining doctor. So I don't think that in the field this is going to really change all that much. My guess is why they did this was that people were finding doctors that perhaps they had been treating with, paid them money to fill out a report, and of course the report was very favorable. And I've heard of situations where the functional capacity evaluation limitations were out of proportion to the treatment records, but the judge had no choice but to approve the case. And I think now what they're saying is that they want to see consistency among the ongoing reports over 2 or 3 years and the opinion letter from the doctor, so there won't be some inconsistencies there. So I think that's really what all this means. And I think this also tells us a couple other things. One is that if you can find a specialist to evaluate you, that's better than an internist or a general family doctor, because a specialist is going to have expertise and knowledge in a particular area, orthopedics, psychiatric, neurology, whatever the case may be, as opposed to a GP. So a functional capacity evaluation from your family doctor about an orthopedic problem or about a psychiatric problem is not going to be given as much weight as one by a specialist, because a specialist would be more persuasive because in theory that person has more education and experience. So that's just another reason to seek out specialists when you can. I think something else going on is that Social Security is becoming a lot more focused on making decisions about cases based on medical records. Testimony, I think, is even less important than it used to be. For a long time, credibility was a big factor. Now, they're not focusing on credibility because that's subjective. That's something that a judge can kind of make a decision on. The judge likes you, the judge finds you believable. Social Security is saying that's no longer enough. We've got to have medical support. This is why medical records are so important. It's very important to go to the doctor, to do it consistently, and to be compliant with all type of treatment. So that's kind of a big picture trend going on. A second part of what Social Security has released is an expansion of who will be considered an acceptable medical source. And this reflects the reality of healthcare in America. Physicians' assistants, PAs, will be considered an acceptable medical source where they were not before. Advanced practice registered nurses with specialized training, will be given acceptable medical source status. And this is important because a lot of people, when they go to the doctor nowadays, they don't necessarily see the doctor all the time. They see a PA, they see an RN. And so now the opinion by the RN or the PA will be given acceptable medical source weight, which means that can be considered as part of the overall evaluation of somebody's claim. Chiropractors, by the way, are still out. Chiropractors are not considered acceptable medical sources. I know many chiropractors find this very offensive, but that's the way Social Security does it. So that's still not considered an acceptable medical source. So I think the good news is we've got a wider variety of acceptable medical sources. I think the bad news is that Social Security now, because they're relying more on medical records, if you cannot afford to go to the doctor, if you have a doctor who doesn't want to cooperate, that can be a bit of a problem. But again, go to the specialist, continue getting ongoing regular treatment, be compliant with your doctor's recommendations. You should be just fine. Nothing is going to change really on the ground very much. This just gives the judge a little more leeway in terms of making a decision and perhaps not giving as much credit to functional capacity evaluations when those are inconsistent with ongoing treatment records. We will see if there's any more change, but my guess is it's not going to really change the way things are actually done in real life. So I hope you found this helpful. If you did, please give it a thumbs up on YouTube, like it on Facebook, and of course, subscribe to our YouTube channel, our Facebook page. We're always putting out new things, and if I can answer any questions for you, please reach out to me as well. This is Jonathan Ginsberg, wishing you well. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the survival kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find this survival kit essential reading. Download your survival kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.